Good afternoon, everyone. Thank you for joining us for another Beale Company webinar, the next in the series of our regular construction law updates. Many of you are regular attendees and will be aware of the format for these by now. Thank you for joining us again. I would like to welcome the new attendees and hope that this webinar is informative and useful for all. Today we are discussing the consultant's duty of care in construction professional appointments. This is largely because of recent developments in the market position in relation to the duty of care which consultants are required to agree to. In particular, in recent months we have seen various new suites of standard form appointments, such as the FIDIC Consultants Model Services Agreement 2017, the White Book, the ACE Professional Services Agreement 2017, and the ICME's Professional Services Contract 2017, the Silver Book. In our view, these all adopt, in one way or another, an elevated duty of care, in that they impose additional and more onerous duties on consultants which have not historically been included in standard form agreements. Also, bespoke agreements, which are usually more onerous than standard forms, are also adopting more and more onerous provisions around the consultant's duties and specifically its duty of care. It is for this reason, as a heading for this webinar, that we have asked whether a consultant's duty of care in its appointment is under attack. As most of you will know, my name is Buckby and I lead the Project and Contracts Advisory team at Beale Company. I'm joined by Simii Sivapalan, who splits her work across the Projects and Contract Advisory team and the Dispute Resolution team. Simii and I have delivered a number of webinars together in recent years. During the next hour, Simii and I will be working through the agenda on this slide. In the first part of the webinar, we will provide a refresher on the standard of care imposed on professionals under common law and the typical approaches in appointment documentation, be it an obligation to use reasonable skill and care, or a higher standard, strict obligations, or obligations which are performance-based or fitness for purpose. We will then touch upon the insurance implications of these provisions. We will then have a brief look back at how duty of care obligations appeared in their previous standard form agreements, and then consider the changing approach to such appointments, with particular reference to the new suite of standard form appointments which I have just mentioned. We will follow this by running through the approach to duty of care obligations typically seen in client bespoke agreements and setting out the risks and mitigation steps in view of these. We'll then look at some recent case law, which in our view shows what is now expected of a consultant in relation to its duty of care. Finally, in the usual fashion, we will identify some drafting tips and practical pointers to mitigate the inherent risks with an enhanced duty of care. We have a lot to get through, so over to Simii.
Thank you, Will. Let's start off the next few slides with a quick refresher on the basics. As most of you will be aware, a professional can owe a duty under common law or in contract. More often than not, the duty is owed in both. The standard of care imposed on a professional at common law is to carry out its services with reasonable skill and care. A duty to use reasonable skill and care, in short, means that the consultant must do or not do what an ordinary skilled and competent practitioner in the same profession would have done or not have done in the same circumstances. The Beale case is regularly cited as being the relevant authority on this. If a consultant can show that he or she has acted in accordance with the usual practice and professional standards current at the time the design was carried out, he will escape liability. This duty of care arises in contract also. For professionals providing services, it is imposed regardless of whether it is referred to in the appointment by the statute, the Supply of Goods and Services Act 1982. If a professional fails to exercise reasonable care and skill under Section 13 of the Act, the professional will be in breach of contract. As you will all be aware, a duty of care provision is nearly always included in a consultant's appointment. The duty of care provision can appear in many different guises, sometimes with a higher standard of care to that of reasonable skill and care. I'll touch upon this later when talking about bespoke agreements. Non-standard conditions of engagement and now some standard forms often contain absolute or strict obligations, therefore going much further than an obligation to just exercise reasonable skill and care. Typical examples in non-standard form agreements include, for example, the professional shall ensure the most efficient and cost-effective solution, or the professional shall comply with the client's requirements, and the professional shall ensure that the finished product meets or complies with the requirements of the client in all respects. The ACE 2009 agreements do not impose strict obligations on professionals. REBA 2010 doesn't impose strict obligations on the architect. However, REBA 2011 has a number of strict obligations, such as the consultant complies with the client's brief and the consultant complies with the statutory requirements. The NEC3 PSC also contains some strict obligations. These are more difficult to identify because the PSC is written in the present tense. The wording the consultant provides must surely mean he or she is obliged to do so. Obligations which state the consultant does the work so that the condition stated for each key date is met by the key date is probably also a strict obligation. The law will take a literal approach to such obligations. If the professional fails to comply with the obligation, he will be in breach of contract regardless of whether or not he or she has acted with reasonable skill and care and/or was prevented from compliance for reasons beyond his control. Strict obligations can appear in many different ways. Obligations to ensure means to guarantee and is an absolute performance obligation. Secure has a similar meaning. These words were considered by the Court of Appeal in John Molam v. Eagle Star. In this case, the Court of Appeal upheld the judge's view that the words ensure and secure in obligations to ensure the regular and diligent progress of the works and to secure the completion of the same in a management contract meant exactly what they said and could not be watered down to an obligation to do more than use best endeavours. As a result, Molam was not entitled to an extension of time for delays that were caused by subcontractors beyond their control. Other words and phrases can be used to create absolute or strict obligations. For example, comply or procure. Procure means an obligation in the consultant to ensure something happens. The same is true for promises to comply with something. These phrases should always be avoided where possible, otherwise failure to comply, etc., whether or not the consultant has exercised reasonable skill and care and/or was prevented from compliance for reasons beyond his control, will mean that the consultant is in breach of contract. Our advice is, where appropriate, to amend these absolute or strict obligations such that they are worded exercising reasonable skill and care the consultant shall, followed by the obligation. In most occasions, this will water down the strict obligation to an acceptable standard, that of reasonable skill and care. Fitness for purpose obligations often arise in non-standard conditions of engagement. In my opinion, this is something which is becoming increasingly common. Fitness for purpose obligations impose a much higher duty on the consultant, as it is an absolute obligation to achieve a specified result, a breach of which does not require proof of negligence or failure to exercise reasonable skill and care. This duty stems from the Sale of Goods Act 1979 and imposes implied terms on any seller of goods that the goods supplied will be of satisfactory quality and where the purchaser makes known any particular purpose are reasonably fit for their intended purpose. If a professional gives a warranty that completed services or works will be fit for purpose, but they are not, damages flowing from the breach are different from and can be higher than those for negligence, which are the reasonable foreseeable loss caused by the negligence. Further, a state-of-the-art defence would not be available. A professional could not argue, for example, that a particular piece of knowledge was not available at the time the design was prepared. Say, as has happened, a professional specified high alumina cement at a time when its unsuitability was not known. The professional would not have been negligent in preparing its specification, as he would be entitled to a claim that at the time of specification, no competent professional in his field would have known that this material was unsuitable, a state-of-the-art defence. The reason why the distinction between fitness for purpose obligations and reasonable skill and care obligations is so contentious is because, as most of you will know, most professional indemnity insurance policies will not include cover for losses arising out of breach of a fitness for purpose obligation. Where a defect arises and no allegations of negligence are made, the policy is unlikely to respond to a claim and insurers may refuse to pay costs associated with the defence of the claim. Finally, fitness for purpose obligations are not always that easy to discover. They may arise by reference to, say, a client's brief, the employer's requirements, or a performance specification. We are also increasingly seeing that fitness for purpose obligations are hidden in the scope, and legal and commercial advisors are missing such provisions. I have mentioned that professional indemnity insurance policies do not provide cover for losses arising out of fitness for purpose provisions. In fact, some insurance policies do not provide cover for breaches of any strict obligations where the consultant has not been negligent. The professional indemnity insurance arrangements of professionals have historically reflected the obligation imposed by common law, that is, to exercise reasonable skill and care. This is what is known as negligence-based insurance, which many of you will have. If a professional has not been negligent but has breached a strict obligation, the insurance is unlikely to respond. This means that strict and absolute obligations, as well as fitness for purpose obligations, will not be covered. This is an important issue. Conversely, the construction market is increasingly seeing legal or civil liability insurance policies. These professional indemnity policies provide insurance for any breach of contract, save for those which are carved out of the terms of the insurance policy, which will more than likely include losses arising out of a breach of a fitness for purpose provision. Our view is that, if possible, consultants should have legal or civil liability insurance given the wider extent of the cover and the increasingly number of strict obligations appearing in appointment documentation. There is obviously a premium consequence for this. Now that we have recapped on the basics, let's look in a bit more detail at the changing approach to duty of care provisions. Historically, standard conditions of engagement included a contractual obligation relating to the duty of care, which imposed a duty that is equivalent to the common law duty of care to exercise reasonable skill and care, often with the additional duty to proceed with diligence, i.e. within a reasonable time. As I have noted, The REBA Standard Form of Appointment 1999 provided at Clause 2.1 that the architect is required to exercise reasonable skill and care in conformity with the normal standards of the architect's profession. In its 2010 edition, this wording was elevated with the additional duty to proceed with diligence. This approach was also the wording adopted in the ACE Agreement 1. As set out on the slide, the now old form of ACE Agreement 1 provided at Clause F2.1 that the consultant shall exercise reasonable skill, care and diligence in the performance of the services. From our experience, clients often found this obligation favourable to the consultant and required the duty of care to be connected to the consultant's experience, qualification and competence on a project. This is typical of client bespoke agreements. The change in shift from the common law duty of care was seen in the NEC3 PSC, which was first published in 2005. The NEC3 PSC is one of the more popular standard forms on the market. Clause 21.2 of the Professional Services Contract provides that the consultant's obligation is to use the skill and care normally used by professionals providing services similar to the services. There is no reference to reasonable skill and care in this obligation. This is not typical drafting in relation to a consultant's duty, as it does not refer to acting with reasonable skill, care and diligence, which is in consultants' appointments. The general view is that the obligation in the NEC3 PSC is akin to the consultant's usual duty of care, that is, reasonable skill and care and acting as a typical professional, and therefore consultants should be comfortable and not worry about this clause. However, notwithstanding this obligation, as I have briefly mentioned, there are various absolute obligations included in the NEC3 PSC, largely because the PSC is written in the present tense. For example, as shown on the slide, Clause 30.3 provides that the consultant does the work so that the condition stated for each key date is met by the key date. Clause 21.2 states that the consultant provides the services in accordance with the scope. This is another absolute obligation. Clause 25.1 provides that the consultant obeys an instruction given to him by the employer. These obligations and others are not subject to reasonable skill and care or watered down. Accordingly, any failure to comply with such obligations will be a breach of contract, and this must be noted. The NEC3 PSC can be seen as an onerous in this respect. Over to Will.
Thank you, Simii. So Simii has provided some vital background for the reasons why consultants should push for an obligation to exercise reasonable skill and care, and why strict and absolute obligations, as well as fitness for purpose obligations, should be avoided. Simii has also looked at the historical approach to contracting in relation to the consultant's duty. Almost halfway through 2017, we are in a position we have not seen for many years. 2017 has already seen the publication of a number of standard form professional services contracts, with additional new forms due to be issued later this year. As outlined on the screen, earlier this year the ACE published a new professional services agreement as well as a sub-consultancy agreement. FIDIC followed by publishing its 5th edition of the Client Consultant Model Services Agreement and Sub-Consultancy Agreement. The Institution of Chemical Engineers has also recently published a new form of professional services contract, which completes its set of standard contract forms and which previously did not include a form dedicated to professional services. The NEC4 suite of contracts are due to be published later this year. We are also aware that REBA will be publishing new appointments in 2017. So, how are these new standard forms approaching the consultant's duty of care? We will examine this over the next few slides. As we mentioned at the beginning of the webinar, the ACE Agreement 1 provided that the consultant shall exercise reasonable skill, care and diligence in the performance of the services. The ACE PSA 2017 goes further than this. In terms which will be familiar to most consultants, there is now an elevated standard of care in the ACE form. Clause 2.1 provides that the consultant shall exercise the reasonable skill, care and diligence appropriate to a consultant qualified in the relevant discipline, engaged in the performance of such services for projects of a similar size, nature and complexity to the project. Similar wording is used in the new FIDIC White Book. Clause 3.3.1 requires a consultant to exercise the reasonable skill, care and diligence to be expected from a consultant experienced in the provision of such services for projects of similar size, nature and complexity. Also, under the ICME Silver Book, the consultant is required to exercise the reasonable skill and care to be expected from a qualified and competent consultant experienced in the provision of services of similar scope, size and complexity to the services. So a very similar approach in all these forms. These clauses clearly link the consultant's duty of care to the consultant's experience, qualification, competence, taking into account, amongst other things, the size, nature and complexity of the project. As I have said, most of you will be familiar with this wording. It's fairly acceptable in bespoke appointments, and our experience has shown that this wording is typically accepted by our consultant clients. My general view is that such a clause is not going to cause any issues from a professional indemnity insurance perspective. However, that said, and whilst this is now perhaps accepted as market standard, in my view such provisions are more onerous on the consultant than the historical approach in the standard forms, which Simii has mentioned. Consultants need to make sure that they are carrying out the services to the correct standard in their relevant disciplines and as would be expected for a project of that nature. For example, the nuclear sector perhaps, or a complex process plant may require a different standard of care than for a simple residential build. This needs to be borne in mind by consultants using these forms. Alongside the elevated duty of care, the new standard forms also introduce further obligations that enhance the consultant's duty. For example, the ICME Silver Book and the FIDIC White Book each contain strict obligations to comply with statutory requirements. The ICME Silver Book at clause 6.1 provides a mutual obligation to comply with all legislation, and that's a defined term. The FIDIC White Book states at clause 3.3 that the consultant shall comply with all regulations, statutes, ordinances and other forms of standards, codes of practice and legislation applicable to the services and the agreement. There is no such general obligation in the previous version of the White Book. An obligation expressed in this way ignores the fact that a professional may, exercising his or her professional judgment, decide to use one and not the other conflicting standard or provide a solution which is a technical equivalent of a standard. In any event, my view is that there is no need for a separate obligation in relation to compliance with statutory and other requirements, as consideration and adoption of such requirements would be caught by an obligation to exercise reasonable skill and care. The ACPSA at clause 2.3 requires a consultant to act in accordance with every reasonable instruction given by the client. Whilst this clause is typically seen in bespoke conditions of engagement, it is once again a strict obligation. Further, the ACE Professional Services Subcontract Agreement provides that the subconsultant must observe, perform and comply with the obligations and provisions of the main agreement, so far as they relate and apply to the subconsultancy services. As well as this being a strict obligation, the issue with this clause is that the main agreement may itself contain performance-based or fitness for purpose obligations which would be incorporated into the subcontract or any other onerous and acceptable provisions for that matter. So there is a real mix of more onerous duties included in these new standard forms. As mentioned earlier, the standard of care in clause 331 of the FIDIC White Book has been brought in line with the widely accepted elevated drafting typical of client bespoke appointments. In a further nod towards the drafting, which might be, I suppose, typical of client bespoke appointments in a number of jurisdictions where fitness for purpose obligations are required, Clause 332 requires the consultant to perform the services with a view to satisfying any function and purpose that may be described in Appendix 1. So services with a view to satisfying any function and purpose that may be described in Appendix 1. While this should focus the parties' minds on agreeing a description of the project objectives, consultants will want to know if this introduces the red flag fitness for purpose obligation, which may not be covered by professional indemnity insurance. Or, in other words, is this a further example of the consultant's duty of care coming under attack? My view is that it is not, and consultants, for the reason I will explain, should not worry too much. Clause 332, which contains the FFP drafting, also states that the consultant's obligation under this clause only applies to the extent achievable using the standard of care in clause 331, without extending the consultant's obligation beyond that required under that subclause. Further, clause 331 states that, notwithstanding any term or condition to the contrary in the agreement, the consultant shall have no other responsibility than to exercise the elevated reasonable skill and care. To me, therefore, it is clear from this that the reasonable skill and care obligation trumps the fitness for purpose obligation in the hierarchy of obligations. In my view, the consultant's obligation in clause 332 is not a fitness for purpose one because of the connected drafting. That said, the drafting, in my view, is entirely unsatisfactory and to a large extent a fudge. It really cannot be good practice to say on the one hand that this must be fit for purpose and then on the other ignore that as we are sticking to reasonable skill and care. I'm not a fan of this amended clause 3. Practically, whilst the drafting is, as I said, limited to reasonable skill and care, I do think it will be easy for employer-focused lawyers to amend the relevant clauses, creating a fitness for purpose obligation. So look out for this. Deleterious or prohibited material clauses are now almost always included in non-standard professional services agreements. In these clauses, a consultant is usually required to state that certain listed materials will not form part of the specification. We often forget that deleterious material clauses are not needed. A professional already has a duty to exercise reasonable skill and care, and this will extend to specifying materials. As such, these clauses, in my view, are not necessary and were typically not included in standard forms of agreement, including the old ACE agreements, for that very reason. However, the ACE PSA 2017 now includes an obligation on the consultant to exercise reasonable skill, care and diligence, not to specify or approve for use any products or materials which are generally known by consultants of the consultant's discipline to be deleterious in the particular circumstances in which they are specified for use to health and safety and or durability of building or structures. In my opinion, this is another additional duty specifically imposed on the consultant. Whether this clause is necessary or not, in our view, there are some issues with the way this clause is drafted and risks enhancing the consultant's duty of care. This clause as drafted is widely drawn. Firstly, references to products or materials which are generally known by consultants to be deleterious is unspecific and open to argument. How will one determine what is generally known by consultants? Secondly, the clause doesn't state whether the obligation applies at the time of specification or the time of use. It probably suggests both. This means that the specification at the time of drafting must not include deleterious materials. The clause also applies at the time of use of the materials. It therefore introduces an ongoing obligation on the consultant which might apply a long time after the consultant has prepared the specification and or at a time when he or she has no duties in relation to the project. This clause, in my view, should have been limited to applying at the time of specification. Further, this express obligation extends to not approving deleterious materials. Depending on the consultant's scope of services, this could further enhance its duty of care. So, in conclusion, whilst this clause is not the most onerous of deleterious materials provisions, it does extend a consultant's duty. A general theme of the standard form professional services contracts is the increased emphasis on collaboration and good faith. This appears to stem from the NEC3 obligation to act in a spirit of mutual trust and cooperation. The ACE PSA 2017 at clause 4.1 introduces an obligation to collaborate in a spirit of trust and mutual support. Under the new FIDIC White Book, clause 1.16.1 requires the parties to act in good faith and in a spirit of mutual trust. Under the new ICME form, the parties are to act fairly, openly, and in good faith with each other. These all suggest additional obligations, additional duties, but what does this mean? There has been limited judicial guidance on this point, particularly the NEC3's spirit and mutual trust and cooperation wording. So much so, I believe that various TC judges have almost deliberately avoided commenting on the clause. David Thomas QC, in his excellent book Keating on the NEC3, states that the NEC3 clause requires the parties to balance their own commercial interests with behaving in an honest, fair and reasonable manner, and not to improperly exploit each other's roles in the contract. This is not dissimilar, in my view, to the TCC's decision in the very recent case of Costain and Tarmac, a judgment which was handed down earlier this year. In this case, Costain engaged Tarmac under a subcontract comprising an amended NEC3 framework contract and NEC3 supply short contract to supply concrete for a new safety barrier on the M1. The supply contract provided for dispute resolution by adjudication followed by arbitration. The right to refer a dispute to adjudication was conditional upon notification taking place within 4 weeks of the referring party becoming aware of the dispute and between 2 to 4 weeks having passed since the notification. On the other hand, the framework contract permitted adjudication at any time. Both contracts included the NEC3 Standard Clause 10.1, requiring the parties to act in the spirit of mutual trust and cooperation. A defect was identified. Costain issued a pre-action protocol letter regarding the dispute. Tarmac replied, arguing that Costain's claim was time barred for not notifying the dispute within 4 weeks under the supply contract. Costain argued that the framework contract permitted adjudication at any time. So the dispute reached the TCC in relation to whether the claim was time barred and the ambiguity arising out of the related time barring provisions. Amongst other things, Costain argued that Tarmac's failure to point out the full effect of the very uncertain time barring provisions was a breach of the spirit of mutual trust and cooperation pursuant to the subcontract. Justice Coulson held that Tarmac had not failed to act in a spirit of mutual trust and cooperation. Tarmac had not lulled Costain into a false belief that a clause was inoperative or would not be relied upon. Clause 10.1 did not require Tarmac to double check that Costain understood the relevant clause. Perhaps not a surprising result. At its highest, the court held that the term mutual trust and cooperation was similar to good faith obligations, therefore creating a positive and perhaps additional obligation to correct a false assumption obviously being made. However, beyond this, it does not create a further obligation for a party to put aside its own self-interest. As I say, this is probably not surprising. However, in my view, the clause demonstrates the intended consequence of the mutual trust and cooperation drafting, an additional duty on the consultant to act in good faith, amongst other things. The ACE PSA 2017 also introduces an early warning regime, very similar to that included in the NEC3 suite, further extending the consultant's duties under the appointment. The early warning regime in the PSA requires the consultant and also the client to notify the other as soon as they become aware of any matter likely to affect the provision of the services, including delay and additional costs. This is clause 4.2 and widely couched. Within 7 days of this notice, the parties are to have discussions and, if appropriate, a meeting to consider actions or measures in response to the matters notified. As I'm sure most of you will be aware, this process is fairly similar to the NEC3 approach to early warnings. Generally, given the wide circumstances in which early warning notices are required, the early warning regime is clearly a significant administrative duty and frankly a burden the consultant must be aware of and which should be reflected in the contract price and managed. This, in my view, is perhaps the most fundamental change in the ACE PSA 2017. In addition, consultants should be aware of the following further points arising from this regime. Any matters agreed are to be recorded in writing, and once such a record is signed, that agreement will be binding on the parties, and if the agreement includes matters of payment or adjustment to the programme, in full satisfaction of any claim. So this does create a potential pitfall for the consultant, since an agreement in relation to the consultant's fee or extension of time may also cover matters pertaining to the consultant's liability. As that agreement will be binding, unless care is taken, it could mean that the consultant's hands are effectively tied in respect of liability. If any such agreement is reached without insurers, for example, being notified, this could prejudice the consultant's position in relation to coverage under its PI policy. This will obviously need to be managed very carefully with insurance and legal advisors. Now back to Simii.
Thank you, Will. I will now consider some example clauses relating to a consultant's duty of care, which we commonly see in bespoke client agreements. The list could be extensive, so I only comment on the more frequent clauses we are seeing. Bespoke client agreements often impose a higher and more onerous duty of care than the common law position. For example, we often see duty of care provisions in bespoke client agreements which state that the consultant shall exercise the reasonable skill, care and diligence to be expected of a properly qualified consultant experienced in carrying out work of a similar size, scope and complexity of the project. As we have just discussed, this is now market standard and commonly accepted wording by consultants. Another common trend in bespoke client agreements is to include variations to reasonable skill and care. These include duties to exercise all skill and care, or all proper skill, due professional skill, or due skill and care. These impose a higher standard of care. For example, proper or due arguably impose a higher degree than reasonable. We also came across obligations to exercise the highest standard, the standard expected of an expert, or the standard of a professional who is a specialist. These variations are clearly different from reasonable skill and care and could impose a higher duty. The issue here is that the consultant will be judged against the higher standard and not against the criteria for using reasonable skill and care. As such, the consultant is more likely to be found negligent in the event of breach. Whether or not a higher duty is acceptable will depend on many factors, including the nature of the project, the experience of the particular firm, and any professional indemnity insurance implications. As we have mentioned, strict obligations and fitness for purpose obligations are common in bespoke agreements. We have already discussed the risks of these. In our view, where possible, more onerous clauses than reasonable skill and care should always be qualified such that the obligation in them is limited to exercising reasonable skill and care. In addition to higher duties than reasonable skill and care, strict obligations and fitness for purpose obligations, there are other approaches in bespoke appointments which raise the consultant's duty of care. For example, obligations to perform the services to the client's satisfaction or even reasonable satisfaction can extend a consultant's duty of care. These obligations require a consultant to guarantee a particular result, i.e. the client's satisfaction. As well as this obligation being subjective and a difficult obligation to meet, this arguably imposes a fitness for purpose obligation, as you are being required to ensure that the client is satisfied with your services. In our view, these obligations put your duty of care under attack and, where possible, should be avoided. We also come across obligations to use best endeavours or all reasonable endeavours. Case law has highlighted that an obligation to use all reasonable endeavours can require a party to act against its own commercial interests. Best endeavours is more onerous and generally means leaving no stone unturned. This may require a consultant to act against their own interests or incur additional costs at their own expense to meet the obligation. Whilst it might be appropriate to accept such a higher standard in respect of certain obligations where a consultant retains sufficient control and the risks can be managed, such as in respect of confidentiality, in our view, an obligation to use reasonable endeavours is more appropriate. Turning now to obligations which may impose compliance with third-party agreements or back-to-back obligations, we commonly see these in bespoke client agreements, and their drafting can be very onerous. Firstly, clients often refer to these third-party agreements and then require the consultant not to do anything which will put them in breach of the client's obligation under those agreements. If phrased in those terms, these obligations are more likely than not strict obligations. Further, the third-party agreements can be very widely drafted, and these agreements may themselves include performance-based and/or fitness-for-purpose obligations which would be flowed down to the consultant. By the same token, back-to-back obligations seek to ensure that all the obligations under the main contract are passed on in exactly the same form to the consultant to ensure there is no gap. Once again, if the first contract is a main contract, it is likely to include obligations which are inappropriate to a consultant, such as obligations for the contractor. If not deleted, we suggest that obligations should be qualified by reference to a consultant's duty to exercise reasonable skill and care, and only having regard to such documents. Finally, consultants should look out for obligations that the consultant owes a duty of care to a third party, such as the same group as the client. Whilst this might be considered as market standard and generally accepted by consultants, this can give third parties rights to bring claims which they would not have otherwise had, significantly extending a consultant's duty and therefore liability. In the next section of this webinar, we will consider some recent case law which are relevant to a consultant's duty of care. There have been a number of interesting cases in recent years. The first is the 2014 decision of the 199 Knightsbridge Development case. We have discussed at length that a consultant is required to exercise reasonable skill and care, or in other words, act in a manner which a typical consultant would do in the same circumstances. In this case, the court highlighted that a consultant blindly accepting normal practice without considering the risks involved is no defence against an accusation of failure to exercise reasonable skill and care. In this case, the claimant was an owner-developer of a prestigious apartment block known as the Knightsbridge. The consultant, the defendant, was tasked with designing a cold water system for the apartment. The contract required the defendant to exercise a reasonable level of skill and care, as was to be expected of a qualified consultant in the same profession, experienced and competent in carrying out work of similar size, scope and complexity as the project. This is fairly typical drafting. The design of the cold water system failed, resulting in a major flood at the apartment. The claimant contended the above duty had been breached. Had the defendant thought through their design, they would have foreseen that failure could have occurred in these circumstances. The consultant claimed that if it was not reasonable for the flooding, it said that at the time, none of the leading building services practices in the UK had identified the problem with the water system. The consultant argued that no reasonable engineer would have foreseen or guarded against the events that occurred. The court held that the consultant was negligent, as it should have foreseen the problem and designed a water system with surge arresters to avert the risk of flood. The court considered the usual authorities in professional negligence cases, including the Bolam Ordinary Skilled and Competent Professional test and the case of Nye Saunders v Alan Bristow, in which the courts held that in determining whether the duty of care has been discharged, the court would consider the evidence at the relevant time from a professional body. The court drew a distinction between the existence of a responsible body of professional opinion and industry practice prevailing at the time. The judge held that despite the absence of a responsible body of professional opinion, the industry practice could not excuse the consultant of its professional duty of care. The court held that the consultant was negligent as it should have foreseen the problem and designed a water system with surge arresters to avert the risk of flood. Importantly, the damage that occurred was of the type that WSP accepted could have been foreseen, and each of the steps that gave rise to it could have been foreseen. The case highlights that a professional cannot divest themselves of their duty of care by simply relying on an unsatisfactory practice in the industry, but has to cast their mind on the potential issues that can arise and advise its clients accordingly. The decision highlights that the Bolam defense has limits, so that a professional cannot simply rely on the fact that no one else in the industry knew of the risks either. This case also has important implications for the duty of care and arguably elevates the standard. Widespread failure within the relevant industry to recognize a particular risk and/or foresee the consequences will not suffice. Professionals will need to look closely and afresh at the potential risks of a piece of advice or action and not rely solely on established industry practice. As an aside, it is very important to point out that the claimant's case failed on the basis that no causation was established. A number of recent cases have considered the interplay between strict requirements and, among other things, obligations to use reasonable skill and care, good industry practice. For example, the cases of Costain v. Charles Haswell Partners and MW High Tech Projects. The court had held that the defendant consultants in both cases were effectively under parallel obligations to use reasonable skill and care and to comply with strict requirements in relation to compliance with contract specifications. And they could be in breach of one of the obligations whilst compliant with the other. So what does this mean? It means that every clause in a contract needs to be examined carefully. Even if a contract includes an obligation to exercise reasonable skill and care, this does not necessarily mean that the consultant's duty will be limited to reasonable skill and care. This is only likely to arise, for example, if drafting provisions that, notwithstanding any other provision of this contract, the consultant shall have no greater duty than to exercise reasonable skill and care. However, whether this works will depend on the overall factual matrix. In light of these cases, we have been advising our clients that an absolute obligation, which, as at the start of the clause, subject to clause X, which is a reasonable skill and care obligation, is unlikely to water down the absolute obligation. If you want to water down an absolute obligation, the clause will need to be redrafted to provide exercising reasonable skill and care, the consultant will, etc. The recent case of MT Hogard v. E.ON also considered the interplay between fitness for purpose obligations and obligations to use reasonable skill and care. Here is a brief summary of the facts. E.ON engaged MT Hogard, the contractor, to design, fabricate and install foundations for 60 wind turbine generators at an offshore wind farm. Clause 8.1x of the contract required the contractor shall, in accordance with the contract, design, manufacture, test, deliver and install and complete the works so that each item of the plant and the works as a whole shall be fit for its purpose as determined in accordance with the specification using good industry practice. The applicable standard was entitled J101, which required a service life of 20 years. Good industry practice required the exercise of reasonable skill and care as well as compliance with the J101 standard. The technical requirements provided that the design should meet the international standard for the design of offshore wind turbines and that the design of the foundation shall ensure a lifetime of 20 years in every respect. Shortly after completion of the works, the grouted connections in the foundation started to fail as a result of a fundamental calculation error in J101. A scheme of remedial works was developed and the remedial works were commenced in 2014. The remedial works amounted to a total cost of €26.25 million. A dispute arose over who should bear the costs of the remedial works. The contractor issued proceedings. E.ON alleged that the contractor was in breach of the contract in respect of the failure to achieve an operational life of 20 years and in breach of the warranty that the works would be fit for purpose and would accordingly be liable for the remedial costs. Among other things, the Court of Appeal held that the provisions of the contract did not contain any freestanding warranty or agreement. The Court held that the wording in Clause 8.1x, that the works as a whole should be fit for its purpose, were qualified by the phrases as determined in accordance with the specification using good industry practice. As defined in the contract, good industry practice required the exercise of reasonable skill and care as well as compliance with J101, but did not impose a warranty as to the length of the operational life. Although the Court of Appeal found that there was no absolute warranty in the contract, the Court highlighted that, if worded with sufficient clarity, a professional could be liable for failing to achieve a specific result, even if it otherwise complied with the relevant standard. A contract can therefore impose a double obligation. As such, an obligation to exercise reasonable skill and care is not always sufficient. The case turned on the Court's interpretation of the contract and is a timely reminder of the perils of imprecise contract drafting. Consultants should be wary that contracts can impose double obligations, that is, an obligation to exercise reasonable skill and care alongside an obligation to meet a specific standard. An obligation in the contract that the consultant is required to exercise reasonable skill and care is not always sufficient. Care needs to be taken to ensure that contracts are worded with sufficient clarity and that contract specifications and requirements are consistent with each other. It will in particular be important to distinguish between those obligations which require reasonable skill and care from those in respect of which warranties are provided for performance or fitness for purpose, given the obvious insurance implications, amongst other things. Each contract taken as a whole, including the contract conditions and the technical requirements, should ideally sing together both in overall approach and detailed drafting. Every effort should be made to eliminate inconsistencies to minimize the risk of unexpected findings on issues of contract interpretation. Interestingly, the Supreme Court has granted permission to appeal this decision, and the case is listed to be heard later this year. It will be interesting to see whether the Supreme Court takes an alternative approach. Now back to Will, who's going to conclude with some drafting tips and practical considerations.
Thank you, Simi. We are running out of time, so I will be brief. We have provided quite a bit of detail in this webinar on the consultant's duty of care. We frequently advise that consultants, where possible, should seek to limit their obligations under their appointment to exercising reasonable skill and care. This should be through an overrided obligation or through qualifying absolute obligations accordingly. This is particularly important in the event that you have a negligence-based professional indemnity insurance policy and not a civil liability insurance policy. Where qualifying strict obligations, do not make these open speech marks subject to a reasonable skill and care provision. We say amend the absolute obligation such that they provide, for example, exercising reasonable skill and care, the consultant shall provide the services or the deliverable. Bespoke agreements will obviously be more onerous than industry standard forms. Look out for fitness for purpose obligations which might not be obvious or included in the terms and conditions. obligations to comply with a performance specification or a client's brief are likely to be fitness for purpose. These must be avoided as losses arising out of fitness for purpose obligations will not be covered by professional indemnity insurance. There are likely to be many other provisions which look to extend consultants' duty of care. For these reasons, and because of the change in landscape in relation to the standard form appointments, we recommend consultants have a civil liability insurance policy, as these are recognised as providing more cover for consultants in the event of breach. These do not only provide cover for failure to exercise reasonable skill and care or in the event of negligence. Finally, and I'm wary of the time, to answer the question posed by this webinar, is the consultant's duty of care under attack? We think so. Standard form and bespoke appointments are becoming more and more onerous. In particular, as a result of the new standard forms, an elevated standard of care is now probably considered as market standard, as are strict obligations, express obligations to avoid deleterious materials, obligations akin to good faith, such as acting in the spirit of mutual trust and cooperation, and early warning regimes. There are other obligations extending a consultant's duty of care, particularly in bespoke contracts. So that is our webinar in relation to a professional's duty of care in the construction field. We hope it has been useful. We haven't got round to answering your questions given the time constraints, but in the usual fashion we'll contact you direct in relation to these, which I hope is okay. On the slide in front of you are some of the articles members of the firm have written in relation to the recent standard forms. These are available on our website www.beale-law.com in the publications section. As soon as the new NEC4 and REBA forms are produced, we will be commenting on these also. Finally, if you have any particular queries regarding today or need assistance in relation to any of the issues we've discussed, please do not hesitate to contact me or Simii. Our details are on the screen. Thank you for joining us, and goodbye.